Hello there, a very good evening and welcome to another edition of the brand new show, The Role of Law, where we discuss the substance of law. The talk of the town right now, of course, is the 20th Amendment to the Constitution. This matter has been challenged in the Supreme Court, and the Supreme Court is currently hearing the petitions on this matter. But what really are we looking for in a constitution here in Sri Lanka? Different countries have different formats of constitutions, and that really determines on how the country functions. It's the grundnorm of any nation. And to discuss these matters and more, we have with us today President's Counsel St. Jayanaga. He is a member of the committee appointed by the Bar Association to review and submit views regarding the 20th Amendment to the Constitution. A very good evening, sir, and welcome to the show.
Good evening.
Sir, first questions first. The Bar Association of Sri Lanka is the preeminent professional body for all attorneys in this country. So this committee report that was prepared and passed at the special meeting of the Bar Council, does this reflect the majority view of all lawyers in Sri Lanka?
It has to be taken that way because the Bar Association gave publicity on newspapers that they are going to hold a special meeting of the Bar Council. The Bar Council consists of delegates from all the bars spread all over the country. There are 80. So those delegates have been informed. So the delegates should have been present on yesterday, that was on the 26th. So they had the meeting of the Bar Council only for this purpose. And what I was told that with one or two amendments, the committee report has been accepted.
Right. So speaking a little bit about the content of this report that was prepared by you and a group of other eminent lawyers, of course, when you speak about constitutional amendments, there is always that little bit of politics that's involved in it and political biases that come into play. There were some dissenting views that were also included in this committee report. Could you comment on that a bit?
Yeah, naturally that has to be expected. Earlier, we had about 15 and some people opted out. But the available members, we initially, on the very first day, we decided that it must be submitted in, each member must submit his view in written form. So all those matters were discussed. So in the process of discussion, there were a lot of dissensions. The dissensions are indicated in the report as written down as footnotes.
Right.
And then there is a separate chapter on that. So in other words, we have considered the views expressed by the members who dissented from the majority view.
Right.
So there were about, say, 9 members agreed totally for this.
So let's speak about the content of this report really. Let's go clause by clause. One of the really contentious clauses in this 20th Amendment that was subject to much debate was the question on whether the President should enjoy complete immunity from suit. Some dubbed this as leaving the President above the law.
That's right.
What is the Bar Association's view on
Now
this?
see, you will see that this sovereignty in our country is with the people. The sovereignty is, unlike in many constitutions, sovereignty is defined in our constitution. Legislative sovereignty is with the Parliament.
Right.
Then the executive sovereignty is with the President. Judicial sovereignty with the courts of law through the Parliament. Then there is fundamental rights and franchise.
Right.
Those also form part of sovereignty of the people. So for earlier, the President, or rather by this amendment, amendment seeks to make the President above the law. That you cannot take him to courts for anything, even for the violation of fundamental rights of persons, either by his action or inaction. Now I will give you the classic example, since that is the judicial history. Now 2018, the President, former President, dissolved the Parliament.
Right.
Now that was challenged. You know how much participation was there at that time.
Right.
That was challenged in the Supreme Court, and a 7-judge bench decided that President was wrong.
Right.
And that dissolution was wrongful.
Right.
So in other words, finally all those applications were fundamental rights applications.
Right.
There the president is not taken to courts, but on behalf of the president, Attorney General will have to come.
Right.
We make the Attorney General respondent in the case.
Right.
So I don't know why they are trying to leave out this jurisdiction.
According to Professor G.L. Pires, who was the chairman of the cabinet subcommittee that was appointed to draft the 20th Amendment to the Constitution, he said that the president will have to be facing suit from so many people who will come to challenge his decisions, and that is the reason why they want to place him on a pedestal above the law.
Well, he might have to face suits from so many people if he violates the fundamental rights of so many people. If he is not prepared to violate the fundamental rights of so many people, he doesn't have to face. And Mr. Maithripala Sirisena, for the period of 4.5 years or 5 years, faced only one case. And that was a very, very big case where he dissolved the parliament. You see? So I don't think, Professor Pires is my guru, but nevertheless, I don't think he's right.
Right.
You see, it doesn't happen that way, People are not going to make frivolous applications, and the Supreme Court, one thing, you must
It's not going to entertain frivolous
applications.
applications.
That's the point. Supreme Court, every FR application you have to apply for leave in the first place. With the leave only you can proceed. You see. So it will be on the very first day it will be thrown out by the Supreme Court if the application is frivolous.
Right. Another problematic inclusion in the 20th Amendment, a clause in the 20th Amendment, was that drew a lot of criticism, really, from even inside the political camp that's in the governing faction right now, was this clause to allow dual citizens to enter Parliament and hold office as a parliamentarian. What is the Bar Association's stance on this?
Well, we were very hard on this because we find a dual citizen has an allegiance to another country,
right,
another state, another king, another potentate. So we don't want a person who is having allegiance or expressing allegiance to another country becoming a ruler in this country. Now this is not simply becoming a dual citizen and buying a property here, but here he becomes a member of parliament,
right,
or possibly a cabinet minister, prime minister, and then the president. Now if you go through those, in fact, by association, we discussed this at length.
Right.
The oaths taken by these people, it is sometimes startling.
Right.
I can, with your permission,
yes,
can I read the oath taken by, not the full, taken by American citizens when they register. Now,
these all were included in the Bar Association's report.
I hereby declare on oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty of whom or which I have heretofore been subject or citizen.
Right.
And I will bear arms on behalf of the United States when required by the law. So that person has to abdicate all allegiance to his mother country. Now that is the oath.
Right.
So a person who has taken that oath, do you think that's the right thing to do?
I was in discussion with President's Counsel Razik Zarruq a few episodes back on the role of law itself, and he said that if you're a citizen of the country, you have to be a citizen of that country. You can't be half a citizen. You can't be 1/4 of a citizen. If you and I are citizens of Sri Lanka, even if you're a dual citizen of Sri Lanka, you would be a citizen of Sri Lanka. And as such, we should be entitled to the same amount of rights. And that is applicable when it comes to representing the public as well. What's your response to this?
No, the point is this. Now see, when this person has expressed his allegiance.
Right.
Now what if that country asks him, give us some information about this country? Don't you think that there is an element of danger? The national security will be compromised. You know how this world politics work? There are wheels within wheels. So one agent can become a danger to the country, whole country. See?
So moving on to another one provision in the 20th Amendment to the Constitution, a clause, it removed a section that highlights the President's duties. And these duties, although not enforceable, you can't file a fundamental rights application against these duties, but included maintaining that reconciliation is
Yes.
allowed in the country, and also
Yes.
respecting the Constitution, of course, which is covered by a number of other provisions as well. The Bar Association has recommended that these provisions or this removal be withdrawn and that these be preserved. Your reasons behind this?
The reason is this, I mean, surely any country, the very first thing, the head of state, the oath that he should take is that he is protecting the constitution of the country. Now, in the present constitution we have, the president must, as a duty, he must protect the constitution, respect the constitution. Then he must promote the national integration. He must ensure the smooth functioning of the Constitutional Council, which is sought to be abolished by the 20th Amendment. Then he must hold free and fair elections. Now, aren't these duties that the president should have? What is wrong with them? Basically, at least the very first duty, that he is going to protect the Constitution and nurture the Constitution, respect the Constitution. If a person says, well, I don't want the Constitution, I am not going to respect the Constitution, he can one day get up and tell the Supreme Court, I am not bound by your judgments. Because you are based on the Constitution, but I am not going to respect that Constitution. I don't know why the drafters of this Constitution is trying to leave out those. I mean, those are, as you say, there's no sanction attached to them.
Exactly.
But they carry a powerful message to the nation that I am here to protect the Constitution.
But conversely, if there is no sanction attached to them, is there really a point in having these in our Constitution?
So it is rather better to have them rather than not have them.
Right.
You see? No, you can't say that there is no sanction, but now he becomes part of the Constitution. He becomes part
constitutional creature.
Constitutional creature. Otherwise, he will be out of the Constitution. Now see this FR, the right to file a fundamental rights application against the president. The president might turn around and say, no, I am not within your Constitution. I am outside your Constitution. I am not respecting the constitutional provisions.
Let's take a look at some of the provisions that the Bar Association has really agreed upon that were included in the 20th Amendment to the Constitution. This was regarding the composition of the Constitutional Council. Now, in the beginning of the 19th Amendment, the drafting stage of the 19th Amendment, a majority were proposed to be members of the civil society. So unelected members of the civil society were proposed in the 19th Amendment in the draft bill to be the majority members in the Constitutional Council, while there was a small minority that was allotted to elected representatives. However, the committee stages of the 19th Amendment, there were a flurry of amendments that were brought in, and this was flipped upside down. The ratio switched. There was a minority representation from civil society and a majority representation of elected representatives. But the Bar Association seems to be in favor of elected representatives only, exclusively being a part of the Parliamentary Council as it's known now, or will be known in the 20th Amendment to the Constitution. Reasons for this?
The reason is that, as I said earlier, the sovereignty of the people is defined in the Constitution. The legislative sovereignty is through the Parliament.
Right.
And the executive sovereignty through the president. So, where does the civil society members fit in? They have no role to play.
Right.
In the scheme of sovereignty, they have no role to play.
Right.
That is the basic reason. And also, selecting 1 or 2 or even 7 or 10, my personal opinion is also that that may not. What basis and what is the criteria?
Right.
There are a lot of people say that there are learned people, there are professors, there are not so learned people, professionals, but nevertheless, now these are people elected. But what I feel is that in the Parliamentary Council there is I debated there is the composition of the Parliamentary Council. I am not in total agreement. That I personally feel that all those political parties which are represented in Parliament should
have a seat.
Should have a seat in the Parliamentary Council. But here what do we have? Speaker, Prime Minister, Leader of Opposition, and then two representatives from the Prime Minister and leader of opposition, possibly to represent various communities. Otherwise, there is no point, no.
Exactly.
That is the whole purpose. But I think it will be more comprehensive had they thought of that other aspect as well.
You spoke about the 2018 decision of the President to dissolve Parliament. It caused a stir then. A similar provision in the 20th Amendment has caused a little bit of a discussion right now regarding the President's power to dissolve Parliament. The Bar Association, however, has taken the stance that this is really not something that should be included in the 20th Amendment.
No. Bar Association has not taken that decision. Bar Association says that, first I will come to this 20th Amendment. The proposal in the 20th Amendment is President can dissolve a
within 1 year.
Parliament which is formed after dissolution of the previous government, previous Parliament,
right,
within 1 year.
Right.
The President has plenary power of dissolution of Parliament. Now the amendment adds something to it from time to time, which is not found in the Constitution today.
Right.
From time to time, President can dissolve. And then there is an exception to that. His power is restricted to, as a consequence of a general election, if a new Parliament is formed, then President can dissolve Parliament only after 1 year.
Right.
But if the new Parliament has been formed after the expiration of the time of the previous Parliament,
right,
which is not a dissolution by the President,
right,
after expiration of the time, full time,
yes,
5 years or whatever,
okay,
then what? The President can dissolve that within a day or 2 days or 3 days or even 1 week. Now that aspect has not been seen. In fact, I made my submissions on this.
Right.
Exhaustively I made my submissions on this, the Bar Association. Very 1 or 2 paragraphs I wrote on this. Now that is why they have included that phrase, from time to time. It is not there in the present Constitution. Now present Constitution is very clear. President shall dissolve Parliament, or President shall summon, prorogue or dissolve Parliament. However, provided he shall not do so for 4.5 years,
right,
from the date of a sixth sitting. Rather, very clear, unambiguous provision.
Right.
Now, which has been made ambiguous, I believe, deliberately. That's what I feel.
Right. So this is an attempt to maybe couch an unfettered power, this unfettered power of the President to dissolve Parliament and go back to what we really were.
That's right.
The 1978 Constitution.
Even worse. Yes.
A little bit of a general argument that is being put forth by a number of parties, sir, is the fact that we're really just going back to the 1978 Constitution, and there's nothing wrong with that, because initially this Constitution was drafted and woven in such a way to support an executive president, and that is the most ideal system of government under this Constitution. What would be your response to such a person?
Now, I am against talking or trying to compartmentalize a Constitution.
Exactly.
What we have is a Constitution today,
right,
which has been 19 times amended. The government is trying to amend it again, so which we call the 20th Amendment,
right,
19 times amended. But now see, constitutions why have they been amended? Because from time to time, the society
changes.
A change is needed.
And a constitution is, of course, defined as a living document.
It's a living document. That's right. So, a change is needed. Now, you may recall, in early part of 1990, there was a huge outcry, rather initiated by Lalit, my guru, as well as Gamini Dissanayaka and Premachandra.
Right.
So much so that the public became aware that this executive power enjoyed by the President is too much.
Too much.
Or rather, there are a lot of arbitrary features in that power. So much so that it became a political slogan of all the political parties.
That they will abolish the executive president.
Within 6 months.
Since then.
Since then. 6 months. And some people 1 year. Some people vacillated but yet accepted. But nobody did it. Because, the point is, when we were law student, one lecturer I can remember saying that don't expect a person who gets the power into his hands
to give it up.
Now, I think we also had that experience recently. Somebody said that, that he will give up everything and go to farming, but he didn't do that. You see?
Of course, getting back to the crux of the matter, the content of this report that was compiled by a special committee appointed by the Bar Association, it brought specific focus onto the independence of the judiciary. This matter was also discussed quite broadly, with the president being proposed under the 20th Amendment to the Constitution to be given the powers to make appointments of judges to the superior courts, there's the Court of Appeal and the Supreme Court, as well as the Judicial Services Commission. What was the Bar Association's thinking behind this?
No, it's like this. In a democratic country, as you know, there are 3 pillars, they say, or 3 organs of the government.
Right.
Legislature, executive and the judiciary. Now these 3 organs must act independently as far as possible.
Right.
And in any case, the judiciary must have must be secure and independent. So that is why the Constitutional Council was predominantly established for that purpose, so that certain high positions can be filled up with the approval and recommendation of the Constitutional Council.
So it's not a one-man show.
Not a one-man show. Now here this amendment proposes that the president to appoint the judges.
Right.
President to appoint, now normally when judges are appointed to the superior courts, Chief Justice and the 2 other most senior judges will ex officio becomes the members of the Judicial Service Commission. And which is an independent body, nobody can interfere with it. And that independent commission controls the transfers, disciplinary control of all other minor judiciary.
Right.
So the entire judicial system is in the hands of the Judicial Service Commission and the Chief Justice.
Right.
Now here, CJ is appointed by President. And there is a provision to say, not the 2 senior, President can appoint to any of the 2 judges.
In the Superior Court.
Superior Court.
Right.
And President can even give them leave if necessary. President can even get rid of them by giving reason, by assigning reason. But those reasons are not given. In other words, the President can say, I don't like your face. And you step down. I can appoint somebody else. So right. I think we have dealt with this sufficiently in the Bar Association report. We say no, we can't support this. You see, and also recently they had a different system where, as I said, the 2 most senior judges must become the members. But then they found that if all the 3 judges were former Attorney General Counsel, Aegis Counsel, then the minor judiciary is not represented. So there must be a judge who had come from original court.
Right.
If there is a judge who is even junior, he will get a seat in the Judicial Service Commission.
Right.
That is, he will be representing what we call the career judges.
Right. So I believe this similar thinking would have also fallen into the recommendations of the Bar Association Committee regarding the appointment of the Elections Commission as well, to maintain independence in holding an election.
Yeah, we have in most of those provisions, the Bar Association took up the position. Now earlier, the Parliamentary Council was a mere farce. It was just a
rubber stamp.
But we have said, no, the President may appoint, but the President must get the approval of the
Parliamentary
Council. Approval, not mere observation. The amendment says on the observation. Observation is just nothing, right? But approval of the Parliamentary Council.
So moving our attention towards another provision in the 20th Amendment to the Constitution, one that is, of course, quite problematic when it comes to the exercise of Parliament's power over public finances, which is a constitutional provision. Of course, the Audit Service Commission has been abolished, and also the Procurement Commission has been abolished. And there has been provisions that have been included in the 20th Amendment, a clause to say that state institutions that the government owns a stake of over 50% cannot be audited by the Auditor General. What is the rationale behind this, and what is the stance of the Bar Association?
In my first submission, I elaborately argued on this, but there was some dissents. But I think we have accepted that. We have accepted this, that we are not supporting that provision. The Bar Association is not going to support that provision, because now Audit Commission and Procurement Commission, both commissions have been abolished. Now, procurement means supplies, no? So supplies you have to pay. So you pay money, you buy goods, but you won't audit. Audit Commission gone. So now then lack of transparency there. Auditor General had been empowered to audit government departments, corporations, local authorities, everything except the President and the Prime Minister's offices.
And also companies that have been
And the
established.
companies, as you say. And the companies which have 51% shares or more. Now, one classic example,
Sri Lankan Airlines.
Yeah, Sri Lankan Airlines, Mihin Air. Now, these are big companies.
Lanka Coal.
Lanka Coal, sustaining losses. And the treasury is pumping money. So, it's public money is going into these. And if one were to say, government audits must not audit them, there's something fishy about it. Don't you think so? You see, public is entitled to know what is happening to that money. And as you say, quite rightly pointed out, it's parliamentary control. All those audit reports will be tabled in Parliament. Then the members of Parliament will know. They can debate, they can question, they can query.
Was this the situation that existed in Sri Lanka before the 19th Amendment to the Constitution, or is this a step even further than the 18th Amendment that has been taken?
I'm not quite sure. But I don't think in the 78 Constitution it was found. I don't know. I'm not quite sure about it.
Right. So moving on to also the Secretary General of Parliament, the appointment in that aspect also had been given to the President, the power. And the Bar Association has also not agreed with this provision.
Yeah, because,
your reasons?
Yeah, after all, he has to be quite an independent person. You see, Parliament, because he runs the Parliament, he is the custodian of the Parliament.
Right. So finally, we're in our final few minutes of our show, really. The 20th Amendment to the Constitution is, of course, been taken to the Supreme Court. The matter is being debated there, so on and so forth. The provisions of the 20th Amendment to the Constitution as a whole, when you take a look at this Bar Association committee report, it seems as if one of the salient features is the fact that the Constitutional Council has been replaced by the Parliamentary Committee in the 20th Amendment to the Constitution. And the Bar Association has proposed in many of its submissions in this committee report that approval of the Parliamentary Committee also be sought. Wouldn't this be just a change of name as far as the Constitutional Council is concerned?
But the Constitutional Council was more, as I said, more comprehensive. There were more representation there. But in a way, it's a change of name, all right. But there was one extra word there earlier: recommendation and approval of the Constitutional Council. But here, only the approval of the Parliamentary Council. No recommendation is sought for.
Right.
You see, only the approval. That's all.
Right. So at the end of the day, the general public of this country really have limited access to information when it comes to, especially, not really limited access to information, but understanding regarding these complex constitutional matters. And they look to the Bar Association, of course, to, riddle these things out and sort these out so that these constitutional provisions can be used for the betterment of the general public. What is the course of action that the Bar Association is planning on taking?
I think my personal opinion is that the Bar Association must go to public and then educate the public. At least they can publish news items in the newspapers in a simpler form. Now there is one thing I forgot to tell you. There is a provision for urgent bills in this.
Right.
That is, within 24 hours, the Supreme Court will have to express its view.
Right.
The Supreme Court can borrow some time by asking the President to give further time. That is, maximum of 72 hours.
Right.
So which means member of the public will not be able to challenge that bill.
Right.
Now today, in the present constitution, when the bill is gazetted, we have 2 weeks
days
till it is put to the
order paper of Parliament.
But that has been reduced to 7. So having reduced that to 7, that is the normal bills, and they are talking of urgent bills also. The urgent bills, within 24 hours, the Supreme Court will have to give its verdict. So this is not good. You know, the choice for the people is between a democracy or autocracy. That's the choice.
Right. I believe, sir, we've come to the end of our show. Of course, there are many more matters that need to be discussed regarding the 20th Amendment to the Constitution, and we only have so much of time to do it. But of course, these matters will be discussed in length, especially in the Supreme Court and other eminent institutions in this country, including Parliament as well. All we hope and pray really is that these constitution amendments be brought forth for the betterment of the general public, and that the general public as a whole can really benefit from these constitutional provisions, because of course at the end of the day this is the government that has been formed of the people, by the people and for the people. Thank you very much, sir, for joining us on our show this evening. Thank you very much for taking time off of your busy schedule and coming on our show. And big thank you, of course, to all our viewers out there. Of course, do stay tuned to The Role of Law, which will be telecasting on TV1 every week, Thursday at 7 p.m. and which also will be premiering live on YouTube for all those social media savvy fans of Role of Law. Thank you very much for tuning in, and until we meet again, take care and God bless.